Not so much the regulations. The regulations flesh out some of the detail of the Act, and in some respects the regulations are quite progressive because what they do is promote a mediation facility between investors and the government if there's a dispute with the government. So I don't really have too much quibble with the regulations, and in fact we made submissions on the regulations which the Department of Trade and Industry have actually accepted largely. So one has to give credit where it's due.
Sure.
The real problem is with the Act itself, because the Act itself prohibits recourse to investor-state arbitration, international arbitration, and it diminishes the protection which investors had under bilateral investment treaties which South Africa previously had between the EU member states and South Africa and Switzerland. And there are about 10 of these were terminated in the Zuma administration between 2012 and 2014. The government said at the time, that was the Department of Trade and Industry, that these bilateral investment treaties would be replaced either by a model bilateral investment treaty which would be used to renegotiate new bilateral investment treaties, or by legislation which would give investors similar protection. When this bill was rushed through Parliament in 2015, I actually appeared in the parliamentary committee to object to it. The same assurance was given, but actually in substance, the bill, as it then was, now an act, the Protection Investment Act, severely reduces the protection international investors have in South Africa, because not only does it take away the right to international arbitration, it also removes the right to fair and equitable treatment and full market value compensation in the event of an expropriation.
Are you saying that South African law is inadequate to protect foreign investors as it currently stands?
I mean, that's debatable. I mean, the government would say it's perfectly adequate and you shouldn't give foreign investors more protection than you give domestic investors. On the other hand, we have an investment deficit. Foreign direct investment in this country has been declining since 2014. In the last 4 years, it's declined substantially. And other countries in Africa are doing much better than us, like Egypt, in terms of foreign direct investment, or Rwanda, for example, is a much smaller economy. But so the issue, though, is if investors had greater protection before under these bilateral investment treaties, what do you say to foreign investors that you're now giving them less protection than they had before? If they'd never had the protection they had under the bilateral investment treaties, then I would say the government's position is certainly arguable. But when you're reducing the amount of protection investors get, you're trying to get, as President Ramaphosa is trying to do, $10 billion into the South African economy in the next 5 years. Admittedly, he has, $100 billion. He's raised 20 so far. It's going to, I think, it's going to be a very hard struggle to persuade investors to come into this economy when you're not giving the protection they had previously.
Absolutely. That 20, by the way, we must clarify, is our promises, right? Pledges that have not yet been translated into actual investment on the ground. So I wanted to know, has there been any objection? Has there been any representation to the president after he signed this bill into law?
I don't know. Don't forget, this law was passed in 2015, by December 2015, but it wasn't put into effect. And there was certainly, I was in Parliament when a lot of people from the European Union and other entities objected to it and said that there should be stronger protection for investors. And a number of NGOs made submissions as well when we did. But I don't know whether any objections were made before President Ramaphosa signed this last week. Bearing in mind, this is a product of the Zuma administration. And if there's nothing unconstitutional about the legislation, the president's actually bound to sign it.
Did the president have an option? Could he have decided not to sign this, citing perhaps some of the issues that you're raising here, and send it back to Parliament?
He can only, under the Constitution, under Section 79 of the Constitution, the President can only send a bill back to Parliament, or an act back to Parliament, if he has reservations about its constitutionality. He doesn't have the right not to sign legislation which has been produced by Parliament. On the other hand, I mean, the reality is the President effectively, and it's happened in the past, has what Americans call a pocket veto, where legislation just doesn't get signed. That's happened with the Private Security Industry Amendment Bill, which proposed to indigenize the private security industry. It's happened with other legislation around security where other governments objected to it. In terms of foreign mercenaries and things like that. So there has happened in the past that president simply hasn't signed any legislation, there's not much you can do unless you take him to court to force him to do that.
So it must then be interesting that he has not chosen to do that in this instance, particularly given, as you have raised now, the issue of his direct involvement in trying to raise $100 billion over the next 5 years and create the millions of jobs that he says this country desperately needs. It appears like he's shooting his own foot.
Well, it may be, but in fairness to him, he might not be aware of what's actually in this legislation. And don't forget, the president gets lots of legislation to sign. He would have been briefed that this has been passed by Parliament. He might have raised the issue, why has there been such a long delay? And he would have been told by the Department of Trade and Industry when we were drafting the regulations, we had to get comments on them and so on. But I don't know. I can't speak for the president.
That's Battalion co-chair and partner Herbert Smith, Freehills.